Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family TRO docket, and also following that, we have the probate, guardianship, and civil law docket for Thursday, February 5th, 2026. The time is now 9:45. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the court coordinator. Ms. Liza Rodriguez is the probate court investigator. Video conference co-hosts this morning include Mr. Cordova, Ms. Cuellar, Mr. Hernandez, and Ms. Rodriguez, and Ms. Ramos. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez.
First in person, Counsel Ruben Arce for the family docket, page 1, number 2.
Jessica Nicole Hernandez versus Jose Angel Rodriguez III, cause number 2025 FLA 1619C3. Court marks Mr. Arce present in person, Mr. Juan Garcia present by video conference. Good morning to both.
Good morning. Good morning, Your Honor.
Jessica Hernandez, Jose Rodriguez, are any parties or litigants present? Court finds they are not present. Mr. Arce, Mr. Garcia, go ahead.
Your Honor, good morning, Judge. Ruben Arce for Mr. Rodriguez. Your Honor, I had filed a motion for continuance. My client was unable to leave work, Judge. The reason, Your Honor, that he had requested time off for next week, I believe this matter was set for the 10th. Judge, I was conferring with counsel. I don't think he had an objection to the continuance, Your Honor, but we're just seeing if we could maybe pass it to the 10th for temporary orders on that day, Judge.
That's correct, Your Honor.
Just pull up the court's calendar and see if that is an available date. And I guess you would know the answer sooner than I would, Ms. Flores.
Yes, Your Honor, the case is already set for TOM.
Oh, I see.
Yes, Judge, I guess I didn't explain myself. It was already set for that day.
Understood. Any objection, Mr. Garcia?
No, Your Honor.
All right.
And I've been conferring with counsel, Judge. I think we can reach an agreement as to temporary orders, Judge.
So just remind the court, because we're set for a final hearing on the 10th, but since you haven't been able to have a temporary orders hearing, you can convert that hearing and then at that juncture request that they be approved and ask for a final hearing in the near future.
Yes, Your Honor.
All right. Anything else on this case, Mr. Arce?
No, Judge, it may be one where we will try to see if we can maybe either get an informal mediation going, Judge, to try to resolve it. But we can ask at the next setting and make that request. Judge.
All right. Anything else on this case at this juncture, Mr. Garcia?
No, Your Honor.
Any other cases for either counsel?
None for family or probate, Your Honor.
Good to see you both. Have a great rest of the week.
Thank you, Judge.
Thank you, Judge. You too. Have a good day.
Thank you.
That's all I have, ma'am. Excuse me.
Yes, sir.
Thank you, Judge.
In person is Council Reyes, Your Honor, and Council Benavides Maddox, but they are conferring. Council Loredo also was here present, but I'm assuming he is conferring as well. And the one pending would be Council Javier Guzman, not sure if he's online.
Well, let's call that case. Page 1, case 1, Mauricio Salazar versus Cristina Alexandria Benedict, cause number 2021, FLC 1132C3.
Good morning, Your Honor.
Good morning, Ms. Martinez.
Good morning, Your Honor.
Daniel Martinez, present, participating by video conference. Good morning, Mr. Castillo.
Good morning, Judge. I'm here on behalf of the respondent, Mauricio Salazar.
All right, court marks Mr. Castillo present in person, Ms. Martinez present by video conference. Mauricio Salazar, Cristina Benedict. Are any parties present?
My client is present.
Good morning, Your Honor.
Are you Cristina Benedict?
Yes, sir.
Ms. Benedict, welcome to court. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Mauricio Salazar, if you're present, raise your hand. Court marks Mr. Salazar present in person. Mr. Castillo, Ms. Martinez, what is the announcement?
Judge, we have conferred and we have only one minor issue that I think we can work out. We would ask the court to give us a reset only. We'll probably work it out, but in case we don't, it's a minor issue, I think.
Sure.
Could be worked out, perhaps a week from today, Judge.
Two things. We can certainly do that, Mr. Castillo. It's good to hear that everything but one thing have been resolved. Is that agreement in writing?
We have exchanged an agreement in writing there, but we've been marking on it.
Sure.
We're going back to the office.
It's a lot of work. I certainly understand that. Ms. Martinez, the one remaining issue, is it property related or child issue related?
Your Honor, the one remaining issue is related to the child, and just for clarification purposes, we're in agreement, and I think we can reach an agreement as for temporary orders.
All right, Ms. Flores, give us that setting next week, please.
February the 12th at 9 a.m.
Mr. Castillo, remind the court, and this is also your first appearance, is it not?
It is, Judge, but I did represent him in 2022.
Right, but on this modification,
Yes.
okay.
Yes.
I just want to put this on the record because by policy of the court, first appearances, no service. There was one other, I forget, but in 3 instances, this case has met the policy on 2, no service and first appearance. So for all of those reasons, plus the fact that Ms. Martinez and you have been fruitfully conferring, all good reasons to grant that request, February 12th at 9 a.m. Ms. Martinez, anything else to add on this case?
No, Your Honor, that's it.
Mr. Castillo?
Yes, Judge, we had discussed that the parties should communicate through app close. That was never a part of the agreed order in 2022. But we've discussed it. I think it's a good idea that both parties start employing app close.
Response, thoughts, or objections to that, Ms. Martinez?
Your Honor, I'm in agreement with that, and I will add that to the settlement proposal that we are currently working on so that we have it in writing and signed off by the parties.
The binding Rule 11 agreement now. All right, the app close is hereby approved and so ordered. Mr. Salazar, Ms. Benedict, continue to talk to your lawyers. They've done a lot of work before today, and they have one pending issue to either work out. And if you can't, I'll make a decision for you next week, but certainly keep in contact with your lawyers so that they can continue guiding you through the process. Ms. Benedict, do you have any questions for the court?
No, sir.
Mr. Salazar, by movement of your head, tell the court, do you have any questions for the court? I see no. All right. I wish you both very well. Good luck to all.
Thank you, Your Honor. And that's all I have before the court. May I be excused?
And Mr. Castillo, any other cases?
No, Judge.
Without further probate, no.
Mr. Castillo, Ms. Martinez, it's good to see you both. Have a great day.
Thank you,
Thank
Judge.
you, likewise, Your Honor.
Would you like to get announcements on the other two pending or? should we-
Yes, who was first? Mr. Loredo, Mr. Reyes, or Ms. Maddox? Lourdes Hernandez versus Juan Ernesto Charro, cause number 2026 FLA 95C3. Please call Mr. Reyes, please. Lourdes Hernandez Juan Ernesto Charro, are you present?
Yes.
Welcome to court, Mr. Charro. The court marks you present. You're participating by video conference. Mr. Charro, you were served with process a few days ago, January 26, 2026. Mr. Charro, do you have a lawyer?
Yes.
Who is that person?
Adriana Maddox.
Ah, that's why they're conferring. Understood. Well, I do know that Ms. Maddox and Mr. Reyes are present, so that leads me to believe that they're talking about your case right now. So I will call your case momentarily. All right, stand by, please.
Okay.
That leaves one case on the family law doc. That's page 2, case 4, Vidal Rene Rodriguez versus Ilse Gonzalez Rodriguez, cause number 2026 FLA 98C3. Thank you. Good morning, Mr. Loredo.
Good morning, Your Honor.
Court marks you present. You're in person. This is Vidal Rene Rodriguez, Ilse Gonzalez Rodriguez, cause number 2026 FLA 98C3. Vidal Rodriguez, Ilse Gonzalez Rodriguez. If you're present, please step forward. Speaking to the microphone and tell the court, are you Ilse Gonzalez Rodriguez?
Yes, I am Ilse Gonzalez, the respondent.
Welcome to court, Ms. Gonzalez. The court marks you present. You're in person. Ms. Gonzalez, this is your first appearance in court. Do you have a lawyer?
I do not, and I'm requesting time.
To hire a lawyer?
Yes,
All right, and I do see that you were just recently served, January 26, 2026. Ms. One more thing. Vidal Rene Rodriguez, are you present?
He is present on Zoom, Your Honor.
Mr. Vidal Rodriguez, if you are present, unmute your device and start your video so that the court can identify you and mark you present on the record. Court is making that request electronically now.
Hello. Good morning, hello.
Are you Vidal Rodriguez?
Yes, Your Honor.
Welcome to court, Mr. Rodriguez. Court marks you present, participating by video conference. As you can see and hear from your device, your lawyer is present in person. Mr. Loredo, Respondent Gonzalez advises the court that she is unrepresented and would like time to hire a lawyer. What response?
Yes, Your Honor, we conferred a couple minutes ago. My understanding is Ms. Gonzalez has a couple of questions regarding the TRO. So she would like some time to request counsel. After conferring with her, she says that she would need approximately about 30 days to seek counsel, and so that we can come to an agreement on the temporary orders.
So here's the thing, Ms. Gonzalez, what Mr. Rodriguez, through his lawyers requesting in writing, is a TRO and temporary orders. So our next setting, and I really don't want anyone to lose it if it's available, is a setting next week. That's not a final hearing. That's just for some orders between now and the date of the final hearing. Your final hearing is actually already scheduled for April 16th. So I've got to set this request in the next 2 weeks, and the best date that I have is next Thursday in 1 week. So I can give you time. You just need to understand that you have 1 week. And quite frankly, any person that you hire needs time to talk to you, advise you, learn your facts, give you proper advice, and then prepare you for that hearing. So I can give you time, but I can only give you for the next setting until February the 12th at 9 a.m. Do you understand this?
And there's no other way to get more time because I have an appointment on the 13th with a lawyer.
Well, I tell you what, I have to schedule this right now. And the best day that I can give you is, or the only day that I can give you in the next 2 weeks is February the 12th at 9. Let your lawyers or that lawyer's office know that the reset date is February the 12th at 9. And on that date, on February the 12th at 9, you can let me know whatever it is your situation is at that time, that your meeting is still set for Friday, or they were able to give you a new date, or you talk to some other lawyer, or whatever your situation is. That way I can make the best assessment at that time. But as all lawyers know, what I want to hear is that you tried, right? So just so as long as you come back and you say, Judge, I have a lawyer and I tried, or I don't have a lawyer and I tried. But just as long as you're doing something about your case, you're going to put yourself in a good position. Does all of this make sense, Ms. Gonzalez?
Of course, it makes sense.
Ms. Flores, does the court have Ms. Gonzalez's email address?
No, Your Honor.
Ms. Gonzalez, what is your email address?
It's I_Vero, VERO_G@hotmail.com.
Say it one more time in case we missed it.
I_Vero_G@hotmail.com.
Did you get that, Ms. Flores?
Yes, Your Honor.
All right, so between now and the time that you hire a lawyer, just keep up with your emails, because if the court needs to send you any information, any notices, it's going to go to that email. And Mr. Loredo, by law, can also send you information or request to that email address, and vice versa. Ms. Gonzalez, do you have any questions for me?
Just that it's set at February 12th, but you said that as long as I communicate with my lawyer, or the one that I have a consultation with, and I have proof of that, the chances of me getting another court date with them present are higher. Is that my understanding?
That's probably the best way to say that. I can't prejudge, so I have no idea what your situation is. And I'm not going to tell you exactly what's going to happen because I don't even know, but it's very likely that the court will understand your situation. But I don't want to hear that I did nothing between now and then. I'd like to hear, I tried. Yeah.
Thank you.
Yes, ma'am. Mr. Rodriguez, do you have any questions for the court?
No, Your Honor.
Mr. Loredo, anything else on this case?
Nothing further, Your Honor.
So one more thing, Ms. Gonzalez, because you don't have a lawyer at this point, Mr. Loredo can ethically talk to you about this case. He cannot provide you any, and he won't provide you any legal advice, but he can at least tell you what Mr. Rodriguez's requests are. And if you read those and think about those, you can agree to some of that, all of that, or none of that. It's completely your decision. Any questions on that?
No, Your Honor.
All right, Mr. Rodriguez, Ms. Gonzalez, I wish you both well.
Thank
Have a
you.
good day.
That's all I had,
Thank
Your
you.
Honor. Maybe
Thank you.
excuse.
Yes, sir. Have a great
Thank you,
day.
Your Honor.
We're at 10:04, so let's start the probate docket until attorneys Maddox and Reyes come in.
First in person, Counsel Ronald Rodriguez, page 1, number 1 and 2.
These are companion cases. We call them together. Page 1, cases 1 and 2 in the matter of the estate of Jose M. Ruiz, cause number 2016, PB480L2, and the estate of Jose Manuel Ruiz Jr., 2021 PB7 96L1. Court marks Mr. Rodriguez present in person, Mr. Emilio Davila present in person, Mr. Harold DeValley Jr.,
is present in person. with us.
Court marks Mr. Harold Diwali Jr. present in person. David Ruiz, are you present? Court marks Mr. Ruiz not present. Mr. Valdemar Garcia, are you present? Court marks Mr. Garcia not present. Ernesto Cavazos Jr., are you present? Court marks Mr. Cavazos Jr. not present. Is there any other person present whose name I have inadvertently omitted? Any other person present on this case? All right, Mr. Rodriguez, Mr. Davila, as always, first question. Have you had an opportunity to meaningfully confer this morning?
We have not.
We have not, well, Judge, it's a continuation of the last hearing. If you're-
I understand
But
that.
no, yeah.
Okay.
No.
So talk to each other, because as I see, last hearing, I think it was Mr. Rodriguez had filed something, court had had the benefit. We went forward, knowing that the court would have to go back and review, digest that filing, and we find ourselves in the same situation on the opposite side now. Now, Mr. Davila has filed something. The court would like some time to receive, review, digest, contemplate, then figure out where we go from here. But at least this gives you a few minutes to talk to each other, see if you get anywhere meaningfully between now and the time that I call the rest of the cases. I'll take up announcements at this time. Without knowing anything else, this will be the first contested matter on the court's docket this morning.
Judge, just as an administrative matter, I also filed a motion for continuance of the motion for summary judgment hearing. I filed it way in advance of this hearing. I thought Your Honor was going to set it for today, but Your Honor didn't. So that's something else that's pending. In addition, I issued 2 subpoenas, one from Mr. Davila along with a set of documents that I filed with the court and uploaded it to case line. Same thing. I filed a subpoena for this hearing for Mr. Ernesto Cavazos Jr. to be here present, along with a subpoena Dukas Tekin. That's also been filed and uploaded. So those are 3 additional documents we want the court to consider. When the court has a chance to review the file as well.
Your Honor, may I respond?
You may.
There is the motion that he filed for a continuance of the hearing on the no evidence motion that has in fact been set by the court for March the 19th, number one. And number two, Your Honor, the subpoenas that he issued are the subject of the second motion for protective order that was filed several days ago, Your Honor. But in light of that, we will confer.
Judge, I invite the court to take a look at your docket. I don't think that motion for continuance was set on the day of the no evidence motion for summary judgment hearing. I think that would be unwise, and that's why I asked the court to set it for today. I don't think that's the case. I don't think there's a setting at all. But I'd like the court to, obviously, it undermines the point of the motion for continuance if you set it for the day of the hearing. The point is I want that matter heard, and I'd like to get it heard today. I filed it last week. I don't think Mr.
I'm sorry, what did you file last week that you want set today?
A motion for, Your Honor said a motion for summary judgment, a no evidence motion for summary judgment.
And
on
the
May
setting was
19th.
on what day?
May 19th.
The setting is on May
No,
19th?
not May.
I'm sorry, March 19th, Your Honor.
March 19th.
Yeah, that's setting on the no evidence motion for summary judgment.
It's set for
Because-
March 19th and you're asking for continuance right now?
Yes, because of remember we were here, the court, I lost 2 weeks now because of the resetting of the hearing.
It
don't
wasn't
wanna be-
reset. I said it on the record. Nothing was reset. It's a continuation of an already started hearing. Go talk, please.
Regardless.
Go
of
talk,
the
please.
weeks, Judge.
In-person counsel Montemayor, page 6, number 16.
This is in the matter of the estate of Claudina Liendo, cause number 2025, PBA 90L2. Good morning, Mr. Montemayor.
Good morning, Your Honor. I'm asking the court to give me a little time on this case. I believe I can reach an agreement with the other conservator on this case. And I kind of need to reassess, how we're going to proceed on this.
Well, this is on the matter of the estate of Claudia Liendo,
Actually,
correct?
yeah, I need to go back and reassess, perhaps file an
Sure.
amended.
No, this is by policy of the court. This is your first setting, well taken and granted. But tell the court, Mr. Montemayor, how much time do you believe would be reasonable and necessary?
30 days.
Ms. Flores, give us that, or Ms. Rodriguez, give us that setting.
April 7th at 2 p.m.
All right, any other cases for Mr. Montemayor?
For DCC, Your Honor.
Yes, for DCC.
No other cases.
Always good to see you. Have a great day.
Next in person is Counsel George Juarez. Page 5, number 12.
This is the estate of Norma Baez, cause number 2025 PB 761L2. Good morning, Mr. Juarez. Court marks you present. You're in person. Norma Baez Walker, are you present?
No, ma'am. No, sir. No, Judge, because the only thing that I filed a motion to extend the time
Ah,
to file the inventory, which was due today. And I'm asking the court to give me until April the 1st of this year to file the inventory. I'm required under the last will of the decedent to get a fair market value evaluation by a licensed appraiser.
okay.
And they came and they checked the warehouse, but they said it'll probably be about 3 weeks before they get the appraisal to me.
You've done work and there are things out of your control. I certainly understand that. Well taken. Although you're requesting to April 1st, Ms. Rodriguez, give us the setting close to April 1st, but after April 1st, please.
April the 7th at 2 p.m.
Obviously, no need to attend court on that date if it's filed before. Well taken and granted. Any other cases for Mr. Juarez?
No, Your Honor.
It's always good to see you, Mr. Juarez. Have a great day.
Thank you, Your Honor.
Next in person, Counsel Figueroa, page 5, number 14.
This is in the estate of Marta Yolanda Gutierrez, also known as Marta Yolanda Guerrero Gutierrez, cause number 2025 PB 781L2. Good morning, Ms. Figueroa.
Morning, Your Honor. It's very good to see you.
Likewise, court marks you present in person. Are you Marisela Gutierrez Castañeda?
Yes, sir.
Welcome to court, Ms. Castañeda. The court marks you present in person. The person to your right is your lawyer, Ms. Figueroa. What is the announcement?
Your Honor, we are here on the application to probate the will and for the issuance of letters testamentary for Marta Yolanda Gutierrez.
And are you ready to go forward?
We are, Your Honor.
Ms. Gutierrez Castañeda, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand, Ms. Figueroa. Go ahead.
Your Honor, may it please the court. Ms. Castañeda, would you please state your name and your home address?
Marisela Gutierrez Castañeda, 1701 Mustard Street,
Are you-
Laredo, 78043.
Are you the same Marisela Gutierrez Castañeda who has made an application in this court for the probate of the will of your mother, Marta Yolanda Gutierrez, also known as Marta Yolanda Guerrero Gutierrez, and for the issuance of letters testamentary?
Yes,
And have you read the application?
yes,
Is everything contained in the application true and correct to the best of your knowledge?
yes, it is.
And in fact, you swore to the facts alleged in the application, correct?
Yes.
What was your relationship to the decedent Marta Yolanda Gutierrez, also known as Marta Yolanda Gutierrez, Guerrero Gutierrez?
Her daughter.
Did she pass away on October 25th, 2025 in Laredo, Webb County, Texas, while residing at 2820 Price Street, Laredo, Webb County, Texas, 78043, at the beautiful age of 86?
Yes, she did.
And has it been less than 4 years since the date of her death?
Yes,
So far as you know, is the document which is dated November 23rd, 2020, and attached to the application a true and correct copy of your mother's last will and testament?
yes, it is.
So far as you know, your mother never revoked, destroyed, or canceled the will.
No, ma'am.
Does a necessity exist for administration to her estate?
Yes.
Okay. And does the will name you to serve as independent executrix?
Yes, ma'am.
And is a bond required of the independent executrix under your mother's will?
No,
Does the will provide for an independent administration of her estate and directs that no action will be had in any court in the administration of her estate other than the probate of her will and the filing of an inventory, appraisement, and list of claims that may be required?
yes,
Does the will provide that the independent executrix, which hopefully will be you, has the authority to sell, manage, and dispose of any and all estate property?
yes,
Does the will name the state of Texas or a governmental agency of the state of Texas as a devotee?
no,
After the date of your mother's will, did she have any children or did she adopt any children?
no, ma'am.
Was your mother married once and only once during her lifetime to your beloved father, Henry Edward Gutierrez of Laredo, Webb County, Texas?
Yes,
Was your mother over the age of 18 when she executed her will?
Yes.
So far as you know, was your mother of sound mind when she executed her will?
Yes.
Were the subscribing witnesses to the will Liana Gomez with an address of 609 Fresno Street, Zapata County, Texas, and Graciela M. Brulas with an address of 1027 Claveles Drive, all in Laredo, Webb County, Texas, 78041?
Yes.
Did your mother apply for or receive Medicaid benefits on or after March 1 of 2005?
No.
Are you requesting letters testamentary and to be named the independent executor?
Yes.
Is it correct that you are not disqualified by law from serving as an independent executrix and from accepting letters testamentary?
Yes.
Does a necessity exist for a formal independent appraisement?
No.
As far as you understand, as I have explained to you, the Texas probate law and Texas Estates Code, does your mother's will meet the requirements of the state of Texas to be admitted to probate?
Yes, it does.
Are you asking the court to appoint you as the independent executrix? I'm sorry, the executrix of the will, and also to admit the letters probate?
Yes.
Are you prepared to sign the affidavit of proof of facts, proof of death and other facts, and the oath that the clerk will administer you?
Yes, I am.
Your Honor, that's all I have, and I respectfully request that the court admit the will to probate under the terms and conditions of the will and the testimony the court heard today.
Ms. Castañeda, in your mother's case, cause number 2025 PB 781L2, the court at this time finds that it has jurisdiction over your mother's case, meaning this is the proper court form and venue to consider admitting your mother's will into probate. The court finds that your mother passed away on the 25th day of October 2025 at the age of 86, having left a valid, executed, and unrevoked will dated November 23rd, 2020. The court finds that you are qualified, you are not disqualified from serving. The court finds that after the will was executed, your mother had no other children, none were adopted, and no marriages were dissolved. The court finds that in your mother's will, she did not list the state of Texas or any charitable organization as DBIZs. The court finds that there is a necessity to administer your mother's estate, and you are named to serve without bond. For all of these reasons, the court hereby grants your request, admits your mother's will into probate, and will cause letters of testamentary to be issued out to you. I have reviewed the proposed order filed by your lawyer. It is in due form. I have signed it. I'm tendering the original to the clerk's office. You may sign the documents in front of you. The inventory on your mother's case will be due on
May 7th at 2 p.m.
Ms. Gutierrez Castañeda. The court has granted your request in full. Do you have any questions for the court? Anything else on this case, Ms. Figueroa?
Not on this case. I do have another case on the docket.
Ms. Gutierrez Castañeda, that concludes your case until May the 7th, that your inventory is due. Between now and then, keep in contact with your lawyer. I wish you well, and you have the court's condolences. Have a good day.
On page 17 of the docket, in the estate of Alice Bruni Whitworth, I am co-counsel with Marisela Rangel. Both Mr. Whitworth, the applicant, and Ms. Rangel are appearing virtually.
Page 6, number 17.
This is the estate of Alice Bruni Whitworth, cause number 2026 PB 73L2. Court marks Ms. Rangel present, participating by video conference. Ms. Martha Cigarroa present in person. Are you Stephen Avery Whitworth?
I am, Your Honor.
Welcome to court, Mr. Whitworth. The court marks you present. You're participating by video conference. Your lawyer is on your right, as is Ms. Cigarroa, who is present in person. Ms. Cigarroa, Ms. Rangel, what is the announcement?
Good morning, Your Honor. We obviously, Mr. Whitworth, we filed an application for the probate of the last will and testament of Ms. Alice Bruni Whitworth, and would like to have it admitted to probate pursuant to the testimony that Mr. Whitworth is prepared to give this morning.
Understood. Mr. Whitworth, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do.
You may lower your hand, Ms. Rangel and or Ms. Cigarroa. Go ahead.
Thank you, Your Honor. I'll proceed. Could you please state your name and address for the court?
Steve A. Whitworth, 119 Canterbury Lane, Laredo, Texas, 78041.
And are you the same Stephen Avery Whitworth, also known as Steve A. Whitworth, who has made an application to the court for the probate of the last will and testament of Alice Bruni Whitworth?
Yes, I am.
And also for the issuance of letters testamentary?
Yes, I am.
And you've read that application?
I have.
Is everything in that application true and correct to the best of your knowledge?
Yes, it is.
What was your relationship to Alice Bruni Whitworth?
Husband and now widower.
Did she pass away on December 19th, 2025 here in Laredo, Webb County, Texas, while she was residing at 119 Canterbury at the age of 73?
Yes, she did.
And it has been less than 4 years since the date of her death?
Yes,
And so far as you know, is the document that we attached to the application dated May 23rd, 2022, a true and correct copy of her last will and testament?
yes,
And as far as you know, she never revoked, destroyed, or canceled that will?
yes,
And does a necessity exist for an administration of her estate? And-
limited, yes,
Yes. Does the will name you to serve as independent executor?
yes,
Does the will require a bond of you?
no,
And does the will provide for an independent administration of her estate and directs that no other action be had in any court or probate court in relation to the settlement of her estate, other than the probating and recording of her will and the return of an affidavit in lieu of a statutory inventory, appraisement, and list of claims?
yes,
Does the will name the state of Texas or a governmental agency as a devisee?
no,
As after the date of your wife's will, did she have or adopt any children?
no,
And was she married once and only once to yourself, Stephen A. Whitworth, on June 29, 1974 in Laredo, Webb County, Texas?
yes, for 51 years.
And you all remained married up until the date of her death,
Yes,
and thus she was never divorced.
yes. Oh, no, she was never divorced.
Was your wife over the age of 18 and of sound mind when she executed her will?
Yes,
Were there two subscribing witnesses to the will by the names of Natalie Lewis and Martha Cigarroa?
yes,
And did your wife apply for or receive any Medicaid benefits after March 1, 2005?
no,
Are you requesting letters testamentary to be issued to you as independent executor?
yes,
And is it correct that you are not disqualified by law from serving as independent executor
yes,
or from receiving those letters?
yes,
Does a necessity exist for the court to appoint a formal independent appraiser?
no,
And as far as you understand Texas probate law and under the Texas State Code, does your wife's will meet all the requirements of the state of Texas to be admitted to probate?
yes,
Your Honor, I don't have any other questions of Mr. Woodworth. We did submit a proof of death and other facts that he's prepared to sign here. We did submit an order as well, and he's prepared to sign an oath thereafter.
Ms. Cigarro, anything to add on the record?
No, Your Honor.
All right. Mr. Whitworth, in the case of your wife, cause number 2026 PB 7-3L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court forum and venue to consider your request. The court finds that your wife unfortunately passed away on the 19th day of December 2025 at the age of 73. The court finds that 4 years have not elapsed from the date of her passing. The court finds that she left a valid, executed, and self-proved will that was never revoked, modified in any manner. The court finds that in that will, she did not name the state of Texas or any charitable organization as devisees. Neither did she have any children or adopt any children after the execution of that will. The court finds that she was married once to you for 51 years. The court finds that there is a necessity to administer her estate. The court finds that you are qualified and you are not disqualified from serving. For all of these reasons, the court hereby admits your wife's will into probate and will cause letters of testamentary to be issued out to you. The court has received, reviewed, and considered the proposed order that was filed by your lawyers. It is in due form. I have signed it. The court is tendering the original to the clerk's office. The inventory on your wife's estate is due on or before
May 7th at 2 p.m.
Mr. Whitworth. Do you have any questions for the court?
no, Your Honor. Thank you very much.
Ms. Frankel?
Nothing further, Your Honor. Thank you.
Ms. Cigarroa?
Nothing further, Your Honor.
Mr. Whitworth, the court did hear that you were married for 51 years. The court finds that that is both admirable and exemplary. You have the court's most sincere condolences, sir.
Thank you very much, Your Honor.
I wish everyone well. Have a great day.
Thank you, Your Honor. I don't have anything further. We don't have anything further. May we be excused?
Yes,
Your Honor, likewise, I have nothing further. May I be excused?
yes, ma'am.
It's
Always
good to see you and your staff, sir.
Likewise.
First online, Council Lisa Mar Soto, page 2, number 3.
This is the estate of Maria Guadalupe Lopez, cause number 2022 PB4 109L2. Good morning, Ms. Soto.
Good morning, Your Honor.
Court marks you present in person. Olivero Canales, Jose Luis Castillo. Any other lawyers present? Court finds no other lawyers are present. Applicant Patricia Garcia or contestant Jesus Manuel Lopez. Any parties or litigants present? Court finds no other persons are present, Ms. Soto?
There should be one logged in from my office, Judge. I'm not sure if she left. Maria Guadalupe Reyes. She's here in my office. She did come in. I don't see her on the well though.
Ms. Maria Guadalupe Reyes, are you present? I don't see that, and she is not responding in any event. Ms. Soto, the announcement?
So, Judge, we did go to mediation with Mr. Romero. It was fruitful to get the parties speaking. Every single heir did show up. However, we did not reach a full settlement with all the heirs. We did reach a settlement with one that made arrangements. All of my documents uploaded into case lines prepared for my hearing today. However, I do have one key witness that I do require his testimony, and he was not able to get the day off of work because he took a day off earlier this week to come to the mediation. So I'm just asking for a very short reset just to show, to tell the court how we propose to handle the division of the 3 remaining properties.
This is a movement, albeit small, but in the right direction. So well taken. Ms. Rodriguez, give the court the next available setting on this matter, please.
Would the February 26th setting be too soon?
Ms. Soto?
So actually, I'm not gonna be in the Laredo that day, Judge. Can I get something earlier or the week after that?
Give me something earlier or as soon thereafter. Oh, I see.
March 19th is the next available one, and we have a highly contested case on that day. So it would be,
Well, let me ask you, well, one last questions you don't want to know the answer to, but here goes. Ms. Soto, you're participating by video conference now. Is it possible at all? I don't want to put you in a bad position, but for February 26th, to log in remotely in that event? I tell you what, let me
Yes,
do
Judge,
both.
I can do that.
Let me do both. Let me set February the 26th for a final
Okay.
pretrial hearing. That way, anything that needs to be proven up or entered
Okay.
into as a settlement with any person, you can do that
Yes.
then, or come back at the following setting for that final hearing. So February 26th at
10 a.m.,
for the final pretrial hearing, and then give us a final hearing date, please.
April the 7th at 2 p.m.
Anything
Got
else
it,
on this?
Judge. Not in this
Please.
case, Your Honor.
All right, Ms. Rodriguez.
H2, number 5.
This is the estate of Juan Jose Trevino Gutierrez, cause number 2023 PB498L2. Court marks Ms. Soto present by video conference. Mr. Jonathan Garcia Davalos, are you present?
Device.
Yes, Your Honor.
Welcome to court, Mr. Davalos. Court marks you and Ms. Soto present and participating by video conference. Juan Jose Trevino Quintanilla, Jorge Alberto Gutierrez. Any parties present? Court finds no parties present. Ms. Soto, Mr. Garcia Davalos?
Judge, it's a hearing on my motion to withdraw. I did request a hearing from the court just so that I could put something on the record. It was my client's request that I withdraw from the matter. I did confer with Mr. Garcia Davalos. He does not object to my withdrawal motion. I also conferred with the newly appointed independent administrator. He's not opposed. I will tell the court that that I will be filing, and I would like to keep getting notices because I do have an open claim, that I intend on filing. My client was advised to judge of the hearing, on January 29th. He was served with a copy of my motion and advised via email, that he had a right to show up and object to my motion.
Mr. Davalos, comments, thoughts, objections, response?
Yes, Your Honor, I have no objection to her motion to withdraw as counsel.
The request is unopposed, well taken, and granted. Court is signing that withdrawal. Now, I think, and this is not a legal issue, this is an administrative one, so let me wade through those waters. Ms. Soto, I think that by signing this, you may come off of that e-service list. When you say you have a claim, has that claim been filed into the case yet?
No, Judge, but I will be filing that today.
So let me ask the clerk's office ostensibly, and I just want to make sure that we get this right since counsel brought it up. So by signing the withdrawal, I think her e-service gets removed from that. But at the time that she files a new request, like a claim, then she will be re-added to the e-service list. Is that right?
I believe so, Your Honor, but I'm not 100% sure.
No, Your Honor.
Should I
This is
file-
Court Administrator. The
Go ahead.
Texas e-file system, Your Honor, does the court or the clerk not have the ability to remove attorneys, whoever filed into the case, and if they no longer belong to the case, they themselves need to go into the Texas e-filing system and remove themselves.
So
But the court, since you signed the motion to withdraw right now and you granted it, whatever new settings that are in this case will not be e-served by this court to Ms. Soto anymore, unless she files something into the case.
I see. That
So I can file my claim, Judge, with the clerk's office as required by law, but then I can file a notice of appearance just for service purposes with the district, to the clerk's office, so that I can keep getting notices through e-file.
I think what Ms. Rodriguez, it's an administrative thing. I think the answer is only you can remove yourself from the e-service list, but from our end, it comes off of the court's listserv on this case until you refile.
Okay.
So it's a two-part response. So administratively, you'll always be on the e-serve list through the clerk's office or through the case management program, unless you take yourself off. But for the court's notices, which is something different, you'll come off and then back on.
Yes, I understand. I'll do that, Judge.
Anything else on this case, Ms.? Oh, well, I need. What then? So what then is left pending? Is there any request for relief pending at this juncture, Mr. Garcia Davalos?
Not by counsel Davalos. Independent executor filed his inventory. However, Mr. Jorge Alberto Gonzalez, the prior client of Ms. Soto, who is now who has filed a notice of self-representation, did file a motion to compel independent administrator, but that is not set.
So let's do that. And let me do this on the record now. So there's a pending request for relief that needs a setting, because if not, I'm going to move this case to inactive. But it's a pending request for relief. Give us a setting on that request, please. Yeah, go ahead.
April 7th at 2 p.m. I'm just not sure if it has been served on Mr. Romero.
That'd be an objection properly lodged by Mr. Romero if it in fact hasn't. All right.
Yes,
So
yes, Your Honor. The thing is that he filed a motion without, the motion that he filed, he's saying that he's abiding to all the rules and so forth. So he just simply filed a motion. He didn't file a court setting request or anything. anything else,
So-
so.
Service on others isn't the court's lane, that's the parties and litigants. So I'm sure that any objection to non-services will be lodged if and when appropriate. Well taken. Good on all sides. All right. Anything else on this case, Mr. Garcia Davalos?
No, Your Honor.
Ms. Soto?
No, Your Honor, thank you.
Any other cases for either counsel?
No, Your Honor.
It's good to see you both. Have a great day.
Good seeing
Thank
you.
you.
Next, online is Council Nicole Fagerberg.
Good morning, Your Honor.
Counsel,
Morning,
what-
Your Honor.
Page 7, number 18.
Your Honor, we're here for the motion for entry of a final judgment. This is a condemnation case, and we had a couple of non-participating parties who were essentially former owners who just needed to be named due to lien interests, but they're not objecting to my knowledge. So as long as you simply call out those parties and there's no objection today, we'll be done in 10 seconds.
So let me do this. State of Texas versus SKG Loop Delmar LLC, a Texas limited liability company, cause number 2022 EDA 21C3, Court Marks Counsel Fairberg, present and participating by video conference. Counsel Resnick, present and also participating by video conference. Ostensibly, Counsel Resnick, Mr. Resnick, you're here on behalf of defendant SKG.
That's correct, Your Honor.
Court marks you present by video conference. Once more, Ms. Fairberg and Mr. Resnick, what is the announcement?
Your Honor, we're ready, and we're ready for the entry of the final judgment unless there's any parties objecting today.
There's certainly no objection here, Your Honor, and I know you're disappointed to get this off your docket.
I appreciate the diligence that has gone on to into this case and all cases, but I know that these ones are complex for many moving part reasons. So thank you, Ms. Fairberg and Mr. Resnick. State of Texas versus SKG. Does any person wish to be heard on this matter? Finding no persons present or responsive or objecting, the court will enter the judgment accordingly. How much time would be reasonable and necessary to prepare those documents, counsel?
So, Judge, the final judgment is submitted as an exhibit to the motion for entry, and we've made sure to we have an exhibit cover page, so that way you can simply take out the final judgment. I'm also happy to simply send a copy of the final judgment by email to your coordinator if that's more simple, but the final judgment has already been submitted for your review with that motion for entry.
I think that's
Correct,
perfect.
Your Honor.
I think that's perfect. Just tell the court the date of that filing so we can pull it and I'll sign it.
Sorry, I don't actually have the date of that. Give me one moment.
We got it, Judge.
All right.
You have it.
January 16th, 2026. All right. So I will sign that judgment. Anything else to put on the record on this case, Counsel Fairberg?
That's it. Thank you so much, Judge.
Counsel Resnick?
Honor, thank you so much.
It's good to see you both. Have a great rest of the week.
Thank you, sir.
Next online, Council Raul de la Garza. Page 9, number 22.
Juan Antonio Juarez versus Homesite Insurance Company, cause number 2025 CVF 38L2. Good morning, Mr. de la Garza.
Good morning, Your Honor. How are you?
Very good. Thank you. Court marks you present. You're participating by video conference. Good morning, Mr. Jackson.
Good morning, Your Honor.
Court marks you present. Also present and participating by video conference. Juan Antonio Juarez or anybody else, any other person present on this case? Court finds no other persons are present. Mr. de la Garza, Mr. Jackson, what is the announcement?
Yes, Your Honor. We went ahead and mediated and settled this case, and we have filed the motion in order of dismissal with the court pending the judge's signature. This was also mediated and settled, and I won't screw it up this time, with former Chief Justice Dory Contreras.
Mr. Jackson?
That's absolutely correct.
I noted it on the record at the last hearing, Mr. de la Garza. It's former Chief Justice Contreras has had a very good record at resolving this type of cases, and I know that you pre-select her as a mediator, but obviously it wouldn't happen without all persons coming together and negotiating in good faith. So for whatever that's worth, Mr. de la Garza and Mr. Jackson, I appreciate you both. The court has received, reviewed, and considered that order granting the agreed motion to dismiss with prejudice. Anything else on this case, Mr. De La Garza?
Not from us, Your Honor.
Mr. Jackson?
Not from us, Your Honor.
All right. Any other cases for either council?
No, Your Honor.
It's good to see you both. Have a great rest of the week.
Likewise,
Thank
Your
you,
Honor.
Your Honor.
Have a good one.
Next online is Council Esteban Gonzalez.
Mr.
Good
Gonzalez,
morning,
what-
Your Honor.
Good morning. What page and case are you here for?
I'm here for the estate of Jose Dario Lopez.
Page 2, number 4.
To the estate of Jose Dario Lopez, cause number 2023 PB495L2. Mr. Gonzalez, you here on behalf of the applicant?
Yes, Your Honor. For the dependent administrator, Howard Reiner.
Welcome to court. The court marks you present. You're participating by video conference. Is there any other person present on this case? Court finds no other persons are present. This is set for inventory. Counsel, what is the announcement?
Your Honor, we do have presented to you an inventory appraisement, a list of claims that was filed with the court on December the 18th of 2025. It does list the real property at issue with regard to this estate. We'd ask the court to grant the inventory. Additionally, Your Honor, we do have pending an application for sale of real property that was filed as well, and an application to abandon personal property that's located in the property as we speak.
Sorry, so there's an application for sale and what else?
Application for abandonment of personal property.
Those are also set for today, Your Honor.
I see that. Well taken. All right. And there's one other. There's a claim.
That is pending. That should have been, I believe we filed the response to the claim this week or going in the matter of last week. I know it was due, and I believe the Houston office did file that accordingly.
And I guess I must have missed that. So I have the claim for 151,000. This is from an authenticated secure claim of Lakeview Loan Servicing. So the response that your office filed, what was that response?
The memorandum of allowance approving the claim, Your Honor.
So there is no objection to approving that claim?
No, none at all.
All right. Yes, court clerk and coordinator, if there are orders on the application for the sale of property and the abandonment of personal property. Do you know, counsel, if you or your office filed orders approving those two things?
I believe we do in regular practice, Your Honor. Let me look in the system and see if they were included. If they were not, we can get those filed immediately, but normally we do file those with the actual documents. Let me look at least on the file stamp of at least the inventory. And I don't see one attached there. Application to sell real
Let me hear
property.
from our court administrator, please.
We have on file an order of sale of real property, an order approving the inventory, and the order of abandonment of personal property,
All
which
right.
is all set for today.
Fantastic. The court will receive, review, print those out, and I will sign those without objection. All right. Mr. Gonzalez, anything else on this case?
Just with regard to the memorandum of allowance, it looks like it was filed with the court on the 27th of this month. I'm sorry, of January. And normally we do also include an order allowing the memorandum, but I didn't know if the court can tell me if that was filed. If not, we'll get that filed for you.
All right. Well taken. Court will sign off on those matters. Anything else on this case, Mr. Gonzalez?
No, Your Honor. Appreciate the court's flexibility and letting me up here by Zoom.
Yes, sir. And for you and for all, if and when necessary, glad to help out all persons. Mr. Gonzalez, have a great day.
Thank you, Your Honor. You too. Have a good weekend.
Thanks.
Your Honor, I didn't catch it. Did you approve the claim?
Yes.
Okay.
And I've signed it, and the signed original is here for the clerk.
Thank you, Your Honor.
Yes.
Be excused.
Yes, sir.
Next online is Counsel Hunter Wiley. I'm not sure what case she's here.
What page and case are you here for, counsel?
Good morning, Your Honor. I'm here for the Gallagher Bassett Services Incorporation versus Richard Conway Jr.
I can't make out what you're saying.
Oh, sorry. I'm here for the Gallagher Bassett Services Inc. v. Richard W. Conway Jr.
Page 10, number 24.
Says Gallagher Bassett Services Inc. versus Richard W. Conway Jr. Power Source Transportation Inc. Cause number 2025 CVM 73L2. Ms. Wiley, you're here on behalf of defendant. Court marks you present, participating by video conference. Mr. Vic, help me pronounce your surname, sir.
Vigushin.
Mr. Vigushin, welcome to court. The court marks you present. You're also participating by video conference. Anybody else present on this case?
No, Your Honor.
Court marks no other persons are present. Mr. Vigushin, Ms. Wiley, what is the announcement?
Your Honor, we were hoping to get a bench trial setting. This is about a $9,900 subrogation property damage case governed by the expedited rules. Discovery ends on April the 27th. Deadline for first setting is July 27th, so we didn't know if the court perhaps had some availability in July. I suspect the bench trial would take 1 to 2 hours at most.
Thank you. Comments, thoughts, and response, objections of any, Ms. Wiley?
No objections, Your Honor.
All right, so let's work backwards from there. Ms. Rodriguez, give the court a bench trial date before July 27th that has few cases to allow for a 1 to 2 hour bench trial.
July 16th at 9 a.m.
Give us that's a bench trial final hearing date. Give us a final pretrial hearing 30 to 45 days before that. Give us 45 days, 45 to 60 days.
June 9th at 9 a.m.
May I very much apologize. I'm set for a jury trial in Rockwall County on the 16th of July. Is that the only date that's available that week?
Well, so here's the thing, and I saw our court administrator do this. It isn't. You can have the 14th. The only issue there, though, what I need to put on the record now is, do you have any objection, Mr. Wish, if there is a visiting judge on that day?
No, Your Honor, I don't believe I do. Is there a possibility, since all the counsel and witnesses are from out of town, to do a remote trial, or everything is in person?
So by policy of this court, and I suggest that you and all persons, counsel, litigants, witnesses, just go to the court's websites to familiarize yourselves with the court's policies and local rules. But the court always allows video conferencing for all hearings unless there's a written objection filed far in advance or far enough in advance to get it set. And normally, if there's an objection, I sustain it. So then you should make plans to be here in person. Other than that, the court welcomes all persons to participate by video conference, subject to an objection. Does that help resolve the issue on the 16th?
No, Your Honor, my trial would be in person in Rockwall County, but I wouldn't have any objections to visiting judge, Your Honor, on the 14th. I'll leave it to Miss Wiley if she would.
I guess before I hear an objection, there's a reason why you skirted around that date, and I think that's the reason. Ms. Rodriguez, on the 14th, how many cases do we have?
I have it at 0 at the moment.
This is perfect. So Ms. Wiley, any objection to a bench trial before a visiting judge on July 14th?
No objection, Your Honor.
So ordered. Now, moving forward on July the 9th at 9 a.m., scheduling a final pretrial hearing. Any objection to that from either counsel?
June, Your Honor.
Excuse me, June the 9th.
None for me, Your Honor.
No objection for us, Your Honor.
All right. And there it is. I highly suggest, I mean, it's not me that's going to be hearing the final hearing, but you should attempt to informally negotiate, talk, confer, and formally, if you can, before June the 9th, but definitively before July the 14th. I wish both sides very well. Anything else on this matter?
None for me, Your Honor.
Nothing further, Your Honor.
Have a great day. You're
Yeah.
excused. Oh, Ms. Rodriguez.
Your Honor, do you wish to set a deadline for formal mediation just in case? No pretrial guideline order was filed I'm not sure the complexity of the matter.
Let me give you a definitive deadline to the more benchmarks that you have, the better to keep the case on track. Any objection to the court setting a definitive date to formally mediate by any person?
No, Your Honor.
No, Your Honor.
Any objection to, well, you tell me, would you like the date before the final pretrial? Well, that'd probably be better. So look, just formal mediation is ordered before June the 9th. So when you come to your final pretrial hearing, you can tell the court, we went to mediation and we resolved it, or we didn't, and we're coming back on the 14th. All right. It's good to see you both. I wish you and your clients very well. Have a great day. You're excused.
Thank you too, Your Honor. Thank you.
Next online, counsel Jose Luis Benavides, page 5, number 13.
This is the estate of Hector Jose Factor, cause number 2025, PB 779L2. Good morning, Mr. Benavides.
Good morning, Your Honor. Jose Luis Benavides here on behalf of the applicant, Ms. Zulema Reyes Soto.
Court martial present participating by video conference. Are you Zulema Reyes Soto?
Yes, sir.
Welcome to court, Ms. Soto. Court martial present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Mr. Benavides, what is the announcement?
Yes, Your Honor, this is an application for issuance of letters testamentary. Ms. Reyes Soto is one of the surviving children of the decedent Mr. Hector Jose Factor, and she has filed an application for probate of will, produced in court, and for issuance of letters testamentary.
And all that being said, are you ready to go forward?
Yes, Your Honor.
All right, give me 1 second. Ms. Soto, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Mr. Benavides, go ahead.
Thank you, Your Honor. Good morning, Ms. Reyes Soto. How are you today?
I'm good.
Ma'am, would you please state your full name for the record?
Zulema Reyes Soto,
And what is your relationship to Mr. Hector Jose Factor?
stepdaughter,
Okay. And Ms. Soto, to your knowledge, what is the date of Mr. Factor's death?
October 17th, 2024.
And what was his address at the time of his death?
1104 South Jarvis, Laredo, Texas, 78043.
Thank you. You said 78043, correct?
Yes.
Thank you. Ms. Soto, to your knowledge, did Mr. Factor have any unpaid debts?
Yes.
And to your knowledge, is a probable value of real property and personal property that Mr. Factor owned in excess of $9,000?
Yes.
And have you reviewed the document that was filed with the court purporting to be the last will and testament of Mr. Hector Jose Factor?
Yes.
And are you the same Zulema Reyes Soto that is named in the will as executrix of the will if your mother, Ms. Juana M. Factor, was either incapacitated or deceased at the time of this probate application?
Yes.
And did your mother, Ms. Juana Factor, pass away on February 12th, 2024?
Yes.
Ma'am, were you familiar with your father's signature?
Yes.
And have you reviewed the signatures on the will that was submitted to this court?
Yes.
Did you identify the signature of the will as that of your father's
Yes.
or stepfather's? And to your knowledge, did your stepfather ever revoke this will?
No.
Ma'am, was your stepfather older than 18 when he executed this will?
Yes.
Were any children born to or adopted by your stepfather after the date of this will?
No.
Was any marriage of Mr. Factor dissolved after the will was made?
No.
To your knowledge, does the will name a governmental agency or charitable organization as a devisee?
No.
Ma'am, does the will provide that no action be taken by a probate other than probating this will, filing an inventory and appraisal and a list of claims?
Yes.
And to your knowledge, are you disqualified by law from serving or accepting letters testamentary in this state?
No.
And to your knowledge, is a will self-proving, meaning that the will does not require the witnesses to file an affidavit stating that it is a legitimate will?
Yes.
To your knowledge, was the will witnessed by 2 or more witnesses?
Yes.
And their names are Ms. Rosemarie Cavazos and Anita Cavazos, correct?
Yes.
Do you swear to execute your duties as executrix of the estate truthfully and to the best of your abilities, including ensuring any unpaid debts are paid as required by law?
Yes.
Thank you, Ms. Soto. Your Honor, at this time, I would ask that the document identified by Ms. Soto be admitted as the valid will and executed last will and testament of Mr. Hector Jose Factor. And I would ask that Ms. Soto's application for issuance of letters testamentary be approved and that she be named executrix of this estate.
Right, Ms. Reyes Soto, in your stepfather's case, cause number 2025 PB 779L2, the court at this time finds that it has jurisdiction over this matter, meaning this is the proper court form and venue to consider admitting your stepfather's will into probate. The court finds that he passed away on the 17th day of October 2024, having left a valid, self-proved, executed, and unrevoked will dated May 14, 2013. The court finds that that will was not revoked, modified, changed in any way. The court finds that no children were born, adopted, or are expected since the execution of that will. The court finds that no marriage was dissolved after its execution. The court finds that your stepfather did not name the state of Texas or any charitable organization as devisees. The court finds that there is a necessity to administer his estate, and the court finds that you are qualified and you're not disqualified from serving. For all of these reasons, you have met the requirements. Oh, and I take judicial notice of the entire case file. For all of these reasons, you have met the requirements necessary for the court to grant your request. The court hereby grants your request, admits your stepfather's will into probate, and will cause letters of testamentary to be issued out to you. The court has received, reviewed, and considered the proposed order filed by your lawyer. It is in due form. I have signed it. I am tendering the original to the clerk's office. The inventory on your stepfather's case is due to the court honor before
May 7th at 2 p.m.
You'll sign some documents with your lawyer. You'll get them filed with the court. Ms. Reyes Soto, do you have any questions for the court?
No.
Anything else on this matter, Mr. Benavides?
No, sir, Judge. I do believe that we need to submit or execute rather the oath to serve as executor. We can get that to you. I'm not sure if that was filed yet, but I do believe it needs to be executed, correct?
No, Your Honor, hasn't been filed.
Okay.
It's going to be filed.
All right, so talk to your lawyer, Ms. Reyes. He's going to provide you some documents. You'll sign them and he will file them. Do you have any questions for the court, Ms. Reyes Soto?
No.
I wish you well and you have the court's condolences.
Thanks.
Any other cases for Mr. Benavides?
No, Your Honor.
It's good to see you, counsel. Have a great rest of the week.
Likewise, Your Honor. Thank you. May I be excused?
Yes, sir.
Have a good one. Thank you.
Thanks.
Before we continue with the contested matters, Judge, those are all the identified individuals. May we call the rest of the docket?
Yes, let me call the rest of the docket as the cases appear on the docket if there's no one else present. Page 3, case 6, in the estate of Arthur Jordan Sampson III, cause number 2024 PB 595L2. This is set for inventory. Joseph Michael Dickerson or applicant Jane Ann Sampson. Any persons present?
Your Honor, inventory was filed yesterday, and I do have the surety bond that was filed as well. I'm just waiting for your review.
All right. Uh, Court has signed the surety, just pending the signature on the inventory. Court will do that appropriately. Page 3, case 7, the estate of Emilio Victor Aldape, cause number 2025 PB 535L2. Mr. Frank Barrera, or applicants Rodrigo Adape, Adriana Perez. Any persons present on this case? Court finds no persons present. We're set for inventory. Has that been filed?
There was an affidavit in lieu filed yesterday, Your Honor.
All right. Well taken. Page 3, case 8, the estate of Craig A. Lawrence, cause number 2025 BB 55302. We're set for inventory. Second sitting for inventory. Marcel Lotson, Rolinda Lawrence. Any person present? Court finds no persons present. Has an inventory been filed on this case?
No, Your Honor.
Give us one more setting before we issue out a show cause. It was 30 to 45. So ordered. Two cases, looks like companion cases. The estate of Maria Dolores, cause number 2025 BB 710L2 and 2025 BB 711L2. Victor Villafranca, are you present? Court finds counsel not present on both cases. Applicant Sid Aldo Trevino, are you present? Court finds applicant not present. We're set for inventory. Has an inventory been filed?
That is correct, Your Honor. Inventory has been filed for both cases as of yesterday.
Court will review that and approve those as required. The estate of Cecilia Hinojosa, cause number 2025 PB 749L2. Elizabeth Vela, attorney Elizabeth Vela, or applicant Abiel Rolando Hinojosa. Anybody present? Court finds no persons present. This is set for an inventory. Has one been filed?
Yes, as of yesterday.
Court will review that and approve it appropriately. Page 6, case 15, the estate of Marta Luisa Maldonado, cause number 2025 PBA 44L2. Attorney Keith Franklin, or applicant Jose Alfredo Maldonado. Any persons present? Court finds no persons present. We're set for inventory. Has one been filed?
Yes, Your Honor. Inventory was filed back on January 30. However, I don't believe it's past the 10 days.
Right. So place it in the queue for the court's review, and I'll sign it once that has elapsed. Page 7, case 19. RP Card Systems LLC versus Mikolobos Restaurant and Sports Bar Inc. Cause number 2025 CVK 1520C3. Counsel Nathan Chu, are you present? Court finds counsel not present. RP Card Systems LLC or defendant Michelob's Restaurant and Sports Bar Inc. Anybody here on this case? At the last hearing, the court granted substituted service. Has defendant been served?
No, Your Honor, they haven't paid for a reissuance for either defendants.
That was done almost 2 months ago. This case is dismissed for want of prosecution. Court will prepare its own order. Page 8, case 20. Poly Leasing Corporation versus RS Transportation Services LLC, Ana Romero. Alio Romero, cause number 2025 CVK 1982C3. Attorney Schlettenall, or any other person. Anybody present on this case? Court finds no persons are present. The court will consider that default judgment by submission and will sign it if appropriate. In case it isn't, give us a final setting in 30 to 60 days.
An agreed judgment was received or filed yesterday, Your Honor.
Fantastic. The court will receive that and sign off. That concludes that case. Page 9, case 21, Christine Garza versus Allstate Vehicle and Property Insurance Company, cause number 2024 CVF 94L2. This case has been previously dismissed by the court and signed. Page 10, case 23, American Credit Acceptance LLC versus Heriberto Martinez Jr., cause number 2025 CVF 85L2. Counsel Daniel Taylor or Heriberto Martinez Jr. Any persons present?
Mayor,
Has anything been filed on this case since December the 12th? Court,
my notes on February 3rd, no, Your Honor, but let me just double check because we were in court all day yesterday. Let me.
sure.
Your Honor, I do see here that the citation or defendant was served back on December 29th. However, nothing has been filed.
Correct.
Well, I think the consideration that the court is contemplating is that citation was pending. There was no service on the last hearing. Citation has been now executed, but back in December, no persons were present. Today, no one is present. This case is dismissed for warrant of prosecution. Court will prepare its own order. All right, that just leaves two matters before the court. On the family law docket, page 2, case 3, Lourdes Hernandez versus Juan Ernesto Charro, cause number 2026 FLA 95L2. Court marks Mr. Reyes present in person, Ms. Maddox present in person. Lourdes Hernandez, Juan Ernesto Charro, are you present?
Mr. Hernandez is.
Yes, sir.
Court adjourned.
Court marks Ms. Hernandez present in person. Her lawyer is present. Are you Juan Ernesto Charro?
Yes.
Welcome to court, sir. The court marks you present participating by video conference from the office of your lawyer. Ms. Maddox, Mr. Reyes, what is the announcement?
Judge, what's on tap for today are a request for temporary orders, Judge, of the case style 2026 FLA 95C3. Hernandez, in the matter of the marriage of Hernandez versus Charo. Judge, with regard to
I believe my client needs an interpreter, Judge.
We'll begin Spanish language interpretation now.
He's online.
Are you Juan Ernesto Charro?
¿Es usted Juan Ernesto Charro? Sí, yo soy. Yes, I am.
Welcome to court, Mr. Charro.
Bienvenido al juzgado, señor Charro.
You're participating by video conference.
Está participando por videoconferencia.
As you can see, your lawyer is present in person.
Como puede ver, su abogado está aquí presente en persona.
You don't need to translate this, but since it requires translation, I'm going to ask no more than 2 sentences at a time. Go ahead.
yes, Judge. Judge, what's on tap for today are our requests for temporary orders with regard to the minor child. We have agreed as follows.
En lo que está en cuestión el día de hoy son órdenes temporales en referencia al menor y en lo que estamos de acuerdo es lo que sigue.
The parties have agreed to be appointed as joint managing conservators.
Las dos partes han estado de acuerdo a ser conservadores conjuntos.
Mr. Charo would be entitled to standard visitation.
El señor Charro va a tener visitas estándares.
Temporarily, no child support will be ordered, Judge.
No se va a ordenar manutención temporalmente.
Mr. Charo will secure health insurance for the minor child FC in the open market.
El señor Charro va a buscar el seguro médico para el niño FC en el mercado abierto.
And there is debt, Judge, and the following is the agreement of the parties with regard to the servicing of the debt.
Hay unas deudas pendientes y lo siguiente es cómo se va a hacer el acuerdo para las deudas.
There is a loan that was secured by the use of Ms. Hernandez's separate property. And she will continue to pay on that loan maintained with International Bank of Commerce, Judge.
Hay una deuda que se hizo poniendo una propiedad de la señora Hernández, una propiedad por separado como colateral,
que es está al International Bank of Commerce, el IBC.
My client will pay the utilities for the homestead located at 1413 North Diaz, Laredo, Webb County, Texas.
Mi cliente va a pagar los recibos de la luz y agua para la propiedad ubicada en 1413 North Díaz,
Her personal cell phone
su teléfono personal
and any credit cards to her name.
y las tarjetas de crédito que estén a su nombre.
Mr. Charo will pay the 2021 expedition monthly debt.
El señor Charro va a pagar la deuda de la expedición 2021.
By the way, Judge, that 21 expedition will be used by Ms. Hernandez pending the finality of this divorce.
Y esa expedición la va utilizando la señora Hernández ya que se haga todo final.
There is a mortgage on the homestead, Judge, 1413 North Diaz. Mr. Charo will pay the monthly mortgage.
Hay una hipoteca en la residencia en 1413 North Díaz y el señor Charro va a pagar esa hipoteca.
There's another property, 3302 Main, Laredo, Webb County, Texas.
Hay otra propiedad en 3302 Main en Laredo, Texas, el condado de Webb.
Mr. Charo will make the monthly payments on those two properties as well.
Y el señor Charro va a hacer los pagos de esas dos propiedades.
Now, there might be some delinquency on it, Judge, on both of these mortgages as well as the vehicle, but Mr. Charo will come current.
A lo mejor hay unas deudas atrasadas en los vehículos o esas dos propiedades, pero el señor Charro se va a poner al corriente.
Mr. Charo will pay his own personal cell phone as well as for the minor child FC.
El señor Charro va a pagar el teléfono celular de él y el del menor FC.
And he will pay whatever credit cards under his name.
Y él va a pagar las tarjetas de crédito que estén a su nombre.
There is a personal property, Judge. Whatever is in the possession of each party will be used temporarily by whomever has possession of them.
En la referencia de propiedad personal, el que tenga posesión de ella va a tener el derecho de usarlo.
The whatever furnishings, appliances are in the home will be used by Ms. Hernandez.
Los electrodomésticos que están en la residencia van a ser usados por la señora Hernández.
There are some weapons, Judge, that are located at 1413 North Diaz, the homestead.
Hay unas armas que están en la propiedad de que 1413 North Díaz.
The parties have agreed that Ms. Hernandez will maintain possession of these weapons, but she has agreed to preserve the weapons.
La señora Hernández se va a tomar posesión de estas armas y ella las va a conservar.
Now, Mr. Charo is at liberty to go by the house and collect his work clothing, Judge, that he has a need for.
El señor Charro está libre de ir a la residencia a recoger sus ropas de trabajo que él necesita.
He's also going to pick up a vehicle, a 2013 Ford pickup.
También va a ir a recoger una camioneta 2003, una Ford Pickup.
And he will make use of that vehicle pending the finality of the divorce.
Y él va a utilizar ese vehículo en lo que se finaliza el divorcio.
I think I might have hit everything already.
Ms. Maddox.
Yes, I just want to clarify that we have also agreed to a temporary mutual injunction.
That's correct.
También tenemos una orden, una inducción temporal.
And that the parties are prohibited from discussing this case with the minor child
Las dos partes tienen prohibido hablar de este caso con el niño menor,
as part of that injunction.
como parte de ese acuerdo.
That's correct, Judge.
I just want to point out that the parties are joint managing conservators with equal rights and duties pursuant to the Texas Family Code.
Y las dos partes son conservadores con los mismos derechos de acuerdo a la ley de Texas.
And the standard visitation is also pursuant to the Texas Family Code for parties who reside 50 miles or less apart from each other.
Y estamos usando las visitas estándares debido al código familiar de Texas, que familias que viven a menos de 15 millas.
I just want to clarify that that wife will have exclusive use of the residence during the pendency of the divorce at 1413 North Diaz.
Y que la señora Hernández va a tener el uso exclusivo de la propiedad en 1413 North Díaz,
Together with all its contents until future division,
junto con todo lo que se encuentra dentro hasta una siguiente división,
including the firearms,
incluyendo las armas,
which she will keep in a safe place since they are remaining in her possession for now.
incluyendo las armas que ella va a mantener en unos seguros, ya que van a estar bajo su control.
My client will be allowed to retrieve his personal items from the residence on an agreed upon date and time,
A mi cliente se le va a permitir recoger su propiedad en una fecha y una hora que se pongan de acuerdo.
and that includes his Ford F-150 pickup truck
Y eso incluye su camioneta F-150
and his wife will return to him the keys to that vehicle.
y su esposa le va a regresar las llaves de ese vehículo.
He will also pick up his work uniforms
También va a recoger sus uniformes del trabajo
and any other personal clothing or items.
y cualquier otra ropa personal o cosas personales de él.
I believe that is the extent of the agreement, Judge.
Y creo que ese es todo el acuerdo, su señoría.
And upon information that we received today, Miss Diaz has there's like some kind of problem with her expedition vehicle. And my client says he has a mechanic who can address that issue.
Give me one second.
I didn't know that,
Give me one
but-
second. Give me one second.
Ya,
Interpretation, please.
hasta el día de hoy nos fueron notificados que la expedición tiene algún problema mecánico y mi cliente está dispuesto a que él conoce un mecánico que lo pueda arreglar.
We hadn't discussed, Judge. I had discussed the point that it needed the repairs.
Give me one second. Interpretation.
No había hablado de eso, su señoría. Sí hablábamos del tema de que se necesitaba una reparación.
Not gonna say I knew it, but I knew it. Give me one second. Interpretation.
Yo lo sabía.
So it's not the person per se that I think should be the agreement, because any person can fix the vehicle.
No es la persona, porque cualquier persona puede arreglar un vehículo.
But ostensibly, it's the payment of the repairs that would become an issue.
Pero lo que es el tema final sería el pago de la reparación.
Is there an announcement or agreement as to that?
¿Hay un acuerdo sobre eso?
We
If
don't,
they would agree, Judge, we would present them with a bill that it takes to repair the vehicle and they can just pay for it.
well,
Si estuvieran de acuerdo, les presentaríamos un recibo y ellos lo podrían pagar.
and the issue is, we don't know what that cost is. When my client left the home, there was no issue with the vehicle. He's already paying a greater share of the community expenses, and he still needs to meet his minimal reasonable needs.
Cuando se separaron, la camioneta no estaba fallando y él ahorita ya está pagando una parte más alta de la división y tiene necesidades mínimas con que cumplir él.
So what it sounds like to the court, if this is incorrect, you may chime in.
Eso es lo que aparenta para la corte. Si estoy incorrecto, me pueden decir.
Ms. Maddox, it sounds like your client is able, willing, ready, and agreeable to paying for the repairs through his service provider.
Lo que se escucha, señora Marx, es que su cliente está preparado para pagar y hacer los arreglos usando su mecánico.
Correct.
Correcto.
So it sounds to the court what would be fair, right, reasonable, and perhaps necessary is the following.
Lo que suena para el juzgado es que lo que es justo, necesario y razonable es lo siguiente.
Why doesn't Mr. Charro's service provider issue a written quote
¿Por qué no el mecánico del señor Charro les hace una cotización?
and Ms. Hernandez's service provider can issue out a written quote
Y el proveedor del señor Hernández puede también hacer una cotización por escrito
and go with the lesser of the two?
y usar la que sea menor.
Any objection to that, Ms. Maddox?
¿Alguna objeción a eso, señora Marx?
No, Your Honor.
I have
No,
no
su señoría.
objection, Judge. It's absolutely reasonable.
Es razonable, no tengo ninguna objeción.
There it is. All right. One other thing, I didn't hear this on the record. Mr. Reyes, you are the petitioner, one child before the court?
Yes, Judge.
No lo había mencionado antes, pero usted es el peticionador, el que está el solicitante.
I
¿Hay un
heard-
menor?
I heard male,
One child, Judge.
Un menor.
male,
Male.
his
Un
age,
hombre.
his age.
His age,
¿Cuál es?
14.
14 años.
Ms. Hernandez, Mr. Charro, I'm gonna ask that you both raise your right hands.
Señor Hernández, señor Charro, les voy a pedir que levanten su mano derecha.
Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Cada uno de ustedes afirma que el testimonio que van a dar en esta causa va a ser la verdad que los ayude Dios.
Yes.
Yes.
Both have answered yes, you may lower your hand. You're the petitioner. Is your true and correct name Lourdes Hernandez?
¿Su nombre correcto es Lourdes Hernández?
Say that into the microphone. Is your true and correct name Lourdes Hernandez?
Yes,
Did you hear the agreement that was told to the court by the lawyers?
yes,
¿Usted escuchó el acuerdo que se le leyó al juzgado por parte de los abogados?
Is that your agreement with Mr. Charro?
¿Ese es su acuerdo con el señor Charro?
yes,
Sí.
Is that your full agreement?
¿Ese es todo su acuerdo?
yes.
Sí.
Was anything left out?
¿Se dejó algo fuera?
No,
No.
Is there anything you want to change?
¿Hay algo que usted quiera cambiar?
No.
No.
These are only temporary until April the 16th at 2 p.m.
Esos son órdenes temporales hasta abril 16 a las 2 de la tarde.
Do you believe that this agreement with regard to your 14-year-old son is in his best interest?
¿Usted cree que este acuerdo está en el mejor interés de su hijo de 14 años?
Yeah.
Sí.
Same questions to you, Mr. Charro. Is your true and correct name Juan Ernesto Charro?
Mismas preguntas para usted, señor Charro. ¿Su nombre completo es Juan Ernesto Charro?
Yes. Sí.
Yes.
Did you hear and understand all of the agreement that was told to the court by the lawyers?
¿Usted escuchó y entendió todo el acuerdo que se le leyó al juzgado por parte de los abogados?
Yes. Sí.
Yes.
Is that your agreement with Ms. Hernandez?
¿Este es su acuerdo con la señora Hernández?
Sí.
Yes.
Was anything left out?
¿Se dejó algo fuera?
No.
No.
Is there anything you want to change?
¿Algo que usted quisiera cambiar?
No.
No.
This is only a temporary agreement until you come back and for a final hearing on April the 16th at 2.
Estos solamente son órdenes temporales y va a regresar por una audiencia final en abril 16 a las 2 p.m.
Do you believe that this agreement until then is in the best interest of your 14-year-old son?
¿Usted cree que este acuerdo es dar el mejor interés de su hijo de 14 años?
Sí.
Yes.
Right, one final question, Mr. Charro. There's someone to your left. Who is that person?
Una última pregunta, señor Charro. Hay una persona a su izquierda. ¿Quién es esa persona?
The assistant of the lawyer.
It's the assistant to the attorney.
Okay, and the name of that person?
Sandra Cisneros.
Thank you, Ms. Cisneros. I'd just like to put on the record everybody that's before the court.
Nomás quería poner el nombre de todos los que están presentes en la
Miss,
Judge, one final thing, Judge, we agree that we submit, inventories within 30 days.
Una cosa final, nomás quería que estamos de acuerdo en poner inventarios en 30 días.
well taken. You read my mind.
And
Buen
so
punto.
we will exchange sworn inventories by March the 6th.
Vamos a cambiar inventarios para antes de marzo 6.
Yes, sir.
So ordered. Ms. Hernandez, Mr. Charro, the court hereby adopts and approves your temporary agreement in full.
Señora Hernández, señor Charro, el juzgado adopta su acuerdo en completo
And by agreement, the court hereby orders that
y el juzgado ordena
sworn inventories be exchanged
que
on or
los,
before March the 6th.
que los inventarios sean intercambiados antes de marzo 6.
Ms. Hernandez, do you have any questions for the court?
Señora Hernández, ¿tiene alguna pregunta? No.
Mr. Charro, do you have any questions?
Señor Charro, ¿tiene alguna pregunta?
No.
No.
Ms. Hernandez, Mr. Charro, let me tell you something that may not be obvious at this juncture.
Señor Charro y señor Hernández, déjeme les digo algo que a lo mejor no es obvio en este momento.
That although these situations are very hard and difficult,
Estas situaciones son muy difíciles.
it takes a lot of work to get this far already.
Toma mucho trabajo llegar a este punto.
So I commend both of you in your communications to your lawyers and your lawyers' communication to each other.
Y los felicito por la comunicación que tienen entre ustedes y sus abogados.
Ms. Hernandez, do you have any questions for the court?
Señor Hernández, ¿alguna pregunta? No.
Mr. Charro, do you have any questions?
Señor Charro, ¿tiene alguna pregunta?
No.
No.
Keep in contact with your lawyers. I wish you both well. More importantly, I wish your son all the best.
Manténgase en contacto con sus abogados, les deseo lo mejor y más que nada les deseo lo mejor a su hijo.
Pardon me, the temporary orders are due to the court honor before
Las órdenes,
February the 23rd at noon by submission.
las órdenes deben ser entregadas al juzgado en febrero 23.
Good luck.
Very well, Judge. Judge, I have nothing further, my big shoot.
It's good to see you, Mr. Reyes. Good to see you, Ms. Maddox. Have a great day.
Always
Thank you,
good to
Judge.
see you.
Am I excused?
Yes. Leaves one contested matter before the court. Companion cases on page one, cases 1 and 2 of the probate docket. First case is the matter of the estate of Jose M. Ruiz, cause number 2016 PB 48002. The companion case is the estate of Jose Manuel Ruiz Jr., cause number 2021 PB 796 L1. Present in person is Counsel Davila, Counsel Rodriguez. Mr. Harold Davali Jr. is present in person. Mr. David Ruiz is now present in person. Is there any other person present? Pardon me, your name, please,
Holly Horrigan, Judge.
and your relationship to this case?
Counsel for Mr. David Reese.
Ms. Horrigan, welcome to court. The court marks you present. You are in person. And the court marks Mr. Jose Luis Castillo. He is present by video conference. Welcome to court, Mr. Castillo.
Well, thank you, Judge. Good morning.
One more time, is there any other person present in person or by video conference who the court has not recognized? All right. A lot of time between now and the 10:05 when I call this case. Sufficient time to confer, Mr. Rodriguez?
Yes, Judge. I believe we have an agreement. I'd like to read into the record to confirm it with counsel. And then there's a couple of matters that we won't need your court's rulings on in terms of some documents. And I think that will take care of today, depending if we do have an agreement the court approves.
The court will hear it and confirm as necessary. Mr. Rodriguez?
Judge, there's two matters that are currently set before the court today, and then the companion responses. I filed a motion to compel the deposition of Ernesto Cavazos Jr., who, as the court may recall, is the executor of Junior's estate. And then I filed a motion to compel the deposition of Mr. Chito Davila, who is the lawyer, who was previously the lawyer for both estates and now represents Junior's estate. Those were set today, along with, I think, Mr. Davila had a motion for protection, the companion response to that. So the court originally started the hearing last time of however the court wants to. We're here today on the continuance of that hearing. With respect to the deposition of Ernesto Davila, we have reached an agreement on that.
Ernesto,
I'm sorry. There's a lot of names going on. Ernesto Cavazos.
All right.
With respect to the executor of the estate of Junior's estate, Ernesto Cavazos, we've agreed to take his deposition on March the 4th. In person here in Laredo, Webb County, Texas. Mr. Davila will let us know whether he wants it at his office, my office, Mr. Garcia's office, wherever he chooses to have it. As long as it's reasonable accommodations, we'll accommodate them. So that's March the 4th in person. He has agreed, Mr. Davila has agreed on behalf of Mr. Cavazos to give me a full set of the bank statements for Junior's estate from the inception all the way to the present. And those will be due 7 days before the deposition, whatever 7 days before March 4th is. And so that's regarding those documents.
They have been previously produced, but we've agreed to produce them again, Your Honor.
I don't think they have, Judge, but I just need a complete set, whatever. I think we're beyond that now. We have issued two subpoenas for today, Judge, a subpoena for Ernesto Cavazos, along to bring 4 very simple set of documents. One is the attorney-client agreement between him and Mr. Davila. The other one is Mr. Davila's billing statements, Mr. Cavazos' billing statements, and then any official documents signed by Mr. Cavazos on behalf of the estate. Those are the 4 simple documents that
I got two. I apologize. So attorney-client. So the first was the contract. The second was billing statements. 3 and 4 were.
3 is the billing statements for Ernesto Cavazos Jr. For the estate for his time.
And then the fourth is official documents signed by Ernesto Cavazos, which, by the way, Judge, I've uploaded and filed these already. I want to admit that subpoena as plaintiff's exhibit 7 for the purpose of this hearing.
But they're filed into the case, are they not?
Yeah, they're filed in the case, but I just want, okay.
Both are well taken, so they'll be admitted and they're part of the case.
And understood, Judge. For the court's convenience, the court can find it on B554, B554. And it's the actual subpoena and the pinpoint side to that. So we need a ruling on Mr. Cavazos. That we don't have an agreement on those. Mr. Davila says he wants to see what he objects to and what he doesn't. I think they're very simple. That's an issue that sometime before the deposition, we'd like the court to rule on those today, but we certainly need them at least 7 days before the deposition of Mr. Cavazos. So that we.
Well, let me ask you this, Mr. Rodriguez, and I think, as I recall, at the last hearing, the court did inquire of you during examination of Mr. Davila what the purpose of the line of questioning was relevant to the issue that was being considered by the court on that last hearing. And I don't remember the specific response, but I remember my response when I said that the court would grant you some leeway to get to where you needed to be to prove your point. I guess before I hear from Mr. Davila, what is the purpose of the request of those 4 sets?
You mean the billings that they have done against the estate, Judge?
Yes.
My client is an heir to the estate. My client is entitled to all documents related to the estate. Do I need to go further? If there's invoices.
Well, I just want you to crystallize it on the record so that it's on the record. Yes, sir.
No. If we're going to go down that route, Your Honor, I have about another hour worth of cross-examination of Mr. Davila. Like in other words,
I just want you to state your request to the court before I hear a response so that it's crystallized.
Okay. Limited to those documents, Your Honor. Limited to those, because I'm not going to argue unless the court wants to give me the full hearing on Mr. Davila's, which we have an agreement on that. Limited.
I just need to understand the request before I hear a response, because I don't know why you're asking, and you're going to put yourself in a bad position if I don't know why you're asking, and then I get a response.
Your Honor,
So I try to equalize the
frankly,
playing
Judge,
field.
I think the documents speak for themselves.
Well, then I can take a break and review them, but
Okay,
you can
Judge,
just tell me what they are right now.
I'm asking for the attorney-client agreement
Yeah.
between Mr. Tito Davila and the estate in which my client is an heir.
Okay.
I would respectfully suggest that is a very relevant document.
Okay.
And I'm entitled to a copy of it. If they're billing, my client is paying 25% of everything. The second thing is any billing statements that he has that he has made, even if I had 1%, there would be there.
I just need to understand.
So I think that one speaks for itself.
All right.
Reasonable and prudent lawyer and probate judge should figure out why that should be relevant to this case. The second one is,
but not if it's not stated on the record, and that's my point.
Building judge. If Your Honor wants to look at the documents,
all right,
the request.
let's do that. Let's do that. The court will stand at ease to review those documents. If I can't get an answer, I will review. I can read for myself. Let's stand by, please. Welcome once more. Court is back in session and we are on the record. These are two cases, companion cases in the matter of the estate of Jose M. Ruiz, cause number 2016 PB 480L2, and the estate of Jose Manuel Ruiz Jr., cause number 2021 PB 796L1. When last we left off, the parties had announced an agreement subject to and pending the court's thoughts, orders, or resolution on 4 contested items. The court has now had sufficient time to review the requests that were made. Mr. Davila,
Judge,
response?
That wasn't the entirety of our agreement. I'll let you know, there was,
If you want to complete the agreement, you may.
yes. So Judge, subject to your honor's ruling on that, so the first agreement was we were going to produce Ernesto Cavazos March the 4th. They're going to produce the bank statements, which we already covered. Your honor is going to make a ruling on those documents that I brought to your honor's attention. The second motion to compel Mr. Davila, the one that is set for today, we've agreed to reset or continue that hearing to March the 19th. The date that the court had set the motion for summary judgment, subject to the court's approval, and then remove the hearing on March 19th on the motion for summary judgment. Take that off the court's docket. Now, on March 19th.
Crystal, I'm sorry. So the continuation of the already started hearing and remove
The motion for summary judgment.
Understood.
The no evidence motion for summary judgment.
all right.
And in the court, and on March 19th, the parties show up. By that time, hopefully we've taken the deposition of Ernesto Cavazos Jr. We can resume this hearing, the one that is set for today. The court can reset the motion with everybody's calendars here. The court, if the court so chooses, and the court finds that discovery depending on the pending motion on Mr. Davila, the court can then reset the motion for summary judgment hearing at some other date. But more importantly, set this case for a DCO. Let's enter a pretrial guideline order where everybody can be here and we can set set the trial date for everybody else, Judge. And then there's several motions that are currently pending before the court that we'd want the court to, that should be dispositive of the actual distribution of the estate. Just so the court knows conceptually.
So that was number 7, but the motions, what if any is the agreement on those dispositive motions?
No, the agreement on the motion for summary judgment, Your Honor, will reset it on March the 19th.
That was number 5. Yes.
There's other motions before the court that have just been pending there. For example, a motion to distribute both estates. That's not set for today.
Right.
But I'd like to, that is a motion that I'd like, there's no agreement on it, but I'd like the court to set. So March the 19th, we conduct some serious business in this court, hopefully distribute the estate, because the pending trial is for the affirmative claim for fraud and breach.
I apologize. I understand all of that, but so you mentioned 7 things. The 7th was the motions. I just want to know if there's an agreement or not agreement as to that matter.
Well, I think we're in agreement that the court set the motions on March the 19th on a date convenient to our calendars. There's no agreement on the disposition.
Right.
But we want the court to set everything on the March 19th, the other non-dispositive motion. So the court can conduct its business, address the motions. There's objections to counting. There's a motion to distribute the estate. So we'd ask that the court to consider setting those motions. I just want to tell the court, Judge, conceptually, there's 2 things going on here so the court can understand when the court schedules it. One is the court has the administration and distribution of both estates. The distribution of seniors estate, 1/2 which goes to juniors, and in juniors estate that goes 1/4, 1/4, 1/4. That's a ministerial duty. We have a motion to distribute the estate that we ask that the court issue an order to distribute the estate. And the court, that's one issue that we don't need a trial on. The trial isn't for that. The trial is for our affirmative claims that we have for breach of fiduciary duty and fraud against the administrators of both estates. So that's the part that we need a trial in. And that we want the court to enter a pretrial guideline order on March the 19th. And then hear the other motions on March the 19th. So the court sets aside, and if it's not March 19th, Judge, whatever the court, I'm just throwing out March 19th because that's a date that the court already gave us. But I want to give the court a framework to dispose of this case fully by this year. And so I think we need to get this thing on a track record that the court needs to start making some rulings on these motions. I'm not putting the finger on the court. I'm just saying there's a lot of pending motions here
that we need to get set. And so that concludes our agreement. There's no agreement on the other pending motions and everything else, but I think that's the agreement there. So the only thing we would like for you to do, Judge, I think, is confirm that the court can reset us to March the 19th on these pending motions or some other date. And then whenever appropriate, make the rulings on those items, which I know Mr. Davila will have a chance to respond to those. Hopefully I answered your Honor's question, maybe more so than I needed, but if your Honor has any other questions, that's all I have.
Response, Mr. Davila?
Your Honor, we do have an agreement as recited into the record. What we do not have an agreement on is the 4 category of documents, these that are being requested of Ernesto Cavazos prior to his agreed deposition of March 4th. That they're contained in a subpoena ducis tecum that was served on by receptionist 7 days ago. And they are asking your Honor to make a ruling on whether the subpoena ducis tecum that was served on 7 days ago are required to be produced or not. Our response is that we need an opportunity, Your Honor, to file our objections and our privilege log to some of the documents that Your Honor has reviewed in which is the 4 categories of documents, and that then the court make a ruling on what it is that needs to be produced and what does not. So we think it premature for the court to be asked to now make a ruling on production of documents that was requested 7 days ago prior to our objections being filed to them. So what we suggest to try and move this along, Your Honor, is that we be allowed to file our objections in our privilege log, if any, 7 days prior to the deposition of Mr. Cavazos, which is March the 4th. In lieu of this court making a ruling on documents requested 7 days ago being ordered to be produced now prior to our objections being filed.
Ms. Bergen, would you like to be heard?
No, Judge, I'm in agreement with the way Mr. Rodriguez stated our agreement on the record, so I have nothing at this time.
All right.
Yeah.
Go ahead.
Judge, we are set for hearing today. I put everything, I always tried to be diligent in my work. I subpoenaed witnesses to be here. Mr. Cavazos, incredibly, he is the executor of the estate, of Junior's estate. Your Honor's fiat makes quite clear this is to be an in-person hearing. We're all here. I subpoenaed him to be here. He blew off the subpoena, a subpoena that was duly served on his counsel to be here. He blew it off. There is no objections. I told him to bring these very simple documents that are relevant and go to the heart of the matter. He filed no objections. There are no objections to the subpoena ducis tecum. As a matter of law, since there's no objections, I think the court should order him. Number one, the court could issue a bench warrant to the court so choose. We're not asking for that. We reached an agreement regarding his deposition, and I'll have a chance in light of the agreement we have. We're not asking for that. But those documents are very simple. The court now has had a chance to review them. I think they're highly relevant, Judge. They're simple, targeted, and they go to the heart of the case. So I'm not asking for the court to, what Mr. Davila wants to do is to wait 7 days before trial so then he can lodge his objections. So then I don't have the documents, so then I can't question them on those. So Judge, whether the court rules today or tomorrow or next week, I want to have an order that Mr. Davila produce those documents within not the objections, produce the document 7 days before the deposition, because I mean, I'm not trying to hide the ball here. I want to ask him questions about these documents. They're highly relevant. And so that's my position, Judge. Just, you know, if he needs more time to gather them, I said, you can have more time, but I need him 7 days. We couldn't reach an agreement. I'm asking your honor to order that these documents be produced, not today, which by the way, they should have been produced today and brought to court, but at 7 days before the deposition, which I think is reasonable, Your Honor.
Anything else from any person? You say it one more time. Would any other person present like to be heard? All right. And I guess the one thing Mr. Rodriguez mentioned that isn't clear to the court, that whether there's an agreement on, and I guess I'll hear from anybody that wants to be heard, is whether all of these things are agreed to, anything pending agreed to be heard on March the 19th. Response or objections from any person?
No objection, Your Honor. There is a complete agreement with the exception of the production of the documents that
Sure.
were requested 7 days ago. And we'll just add, Your Honor, that Mr. Cavazos did not blow off the subpoena. The subpoena is addressed in the motion, the second motion for protective order that was filed with Your Honor 2 days ago.
All right. I hope we don't get this wrong. And my concern is we'll come back on March 19th and we'll certainly we're going to send out a notice. And then one thing is, I think Mr. Rodriguez mentioned there were multiple things that had been pending or lingering. And I guess if they aren't argued, they're not heard, right? So I guess, is it possible? It may not be, and we're going to have to go through and look through both case files to ascertain what all is filed and not yet either heard or ruled on. Do you all know what is pending so that we can just set it now?
Your Honor,
Judge,
we're much more familiar with the case than Your Honor is, because we have this one
Maybe
case.
you work
and
on
we've
them,
been
yeah,
living
sure.
it. So we would suggest that we file
Fiats.
within a time limit with Your Honor, what it is that we would like to have heard on March the 19th, in lieu of the court having to spend your time going through both voluminous cases to see what it is that you're going to set, Your Honor.
Any objection to that, Mr. Rodriguez?
Actually, Judge, I would, no objection, but a little modification. What I would suggest that the court give us a deadline, maybe Friday of next week, Wednesday of next week, some deadline to submit a fiat or a request for setting to the court. I know the court likes to issue its own fiats, but file a request for setting, identifying the matters that each one of us wants to have set with the court by a certain deadline, a time certain, and then the court will have each of our requests, and then the court hopefully can set those matters for March the 19th. Everything except dispositive motions, Your Honor. Obviously, dispositive motions on motions for summary judgment we're putting off. The court can set those on March 19th together with the trial setting and whatever else the court.
And I guess before I ask Mr. Davila for a response on that, Mr. Rodriguez, so the agreement is that the deposition take place on March the 4th, correct?
That is correct.
Do you think the court should order that those fiats be filed? So what I don't want, right? I want all the parties, lawyers, litigants, and witness energies to go towards preparing for that and hopefully finalizing this. So that being said, would you prefer that the court order that deadline before or after the deposition?
I think, Judge, what I need before the deposition is the court's ruling on those documents. The actual
I
motion.
know, but my question is the fiats.
No,
When do you want the
fiats,
order?
Judge, could be next week.
All right, so
I think 10 days.
So before the
Yeah.
deposition.
Just so Your Honor has time to review it and review its own file and make sure everything's in order.
That's
So I think
fair.
7 to 10 days is a reasonable time to give us a deadline to all parties to submit a notice to the court and a request to have the matter set. And then also the court will have time to set those matters.
Response, Mr. Davila.
that is agreeable, Your Honor, if you
Mhm.
give us a deadline to file fiats as to what it is that we wish to have heard on the 19th. And then Your Honor will make a decision as to what it is that in fact it is going to set.
May I be heard on one thing, Judge? Just conceptually, so the court can kind of start thinking about this case and how it wants to.
I've got a number of issues in the air. Let me just write them down before I lose them. I'm gonna let you go, and I'm gonna remember that there was one thing that I should have put on the record. So one is the agreement, two is the deadline for the fiats. Mr. Rodriguez, go ahead.
Conceptually speaking, Judge, conceptually speaking, Your Honor has two estates that need to be distributed. I think the framework to distribute them is already there. You have objections to accountings, objections to inventories. So the court should set a hearing on distribution, accountings, everything related to the distribution of the estate. Then separate apart from that, this is separate, Judge. You have the affirmative plaintiff's original petitions against both of the defendants. That's I know they're all in one case, but remember, those are ancillary suits that are filed in probate matters. I just want to make sure the court understands those are technically those are separate independent cases. They were filed in probate as ancillary litigation, but those are separate cases. Those are the ones that need their pretrial guideline orders. I had asked the court to consolidate those cases. The court didn't, the litigation cases. The court didn't do it, but the court needs to schedule those for trial. I would suggest senior goes first, and then juniors, but conceptually, that's what the court it should do. I suggest we do most of that on March 19th, so the court can work through that. The reason I'm telling you, Your Honor, is because I know Your Honor wants to read through and see where all the chess pieces are on this thing. So hopefully we can get this thing going in a situation where we put it on track. Let's get Your Honor to make some rulings. Let's get the jury to make its determination, and then hopefully finish this case before the end of the year.
So I tell you what, this case is hereby set for docket control conference on March 19th at 2 p.m. Now, I think both of you may have mentioned that the court does like to issue out its own fiats. So what the court is going to do is going to rely on your fiats to pull all the information out of those, and then we'll issue one out. So please identify what matters you would like to get heard on the day of the docket control conference on March 19th. Hopefully you've gotten to the finish line at that point. If you haven't, the court will issue out some dates. And I guess I'm going to hear it now because things change and you could change your mind before then, I guess. But what the court is going to want to hear is whether there is any agreement as to Mr. Rodriguez's position that the 2016 case, I mean, just by default, just administratively, I think that's correct. However, people may have differences of opinion, so just be prepared for that question from the court as to which case should go first on March the 19th.
Your Honor, could you please check the 2 p.m.? We have it at 9 a.m. I'm not sure if you want to give it.
I'm sorry, March 19th at 9 a.m. I apologize. You're right. Thank you for that. Anything else from any person?
So I just want to make sure, Judge, the current motion for summary judgment that's set for March 19th at 9 a.m. is taken off the docket, correct? By agreement. We want to make sure the record is clear.
That was agreement number 5.
Got it. And then the court
So
said,
let me put it on the record so that we're clear. There is nothing set on March 19th other than a docket control conference, subject to the parties filing fiats, the court extracting that information and sending out its own notice soon thereafter. Those fiats are due to the court on or before February the 13th by 5 p.m. Pardon me. Go ahead, Mr. Rodriguez.
February 13th by 5 p.m. And then we'll talk about the setting and what the court wants to do on that submission on March 19th, right? In other words, we're gonna request.
So, I mean, unless there's a good and valid reason, the court is just going to take all of that information, put it into one fiat. So there's one document signed by the court, filed into the case, and then I'll hear objections as to why the court shouldn't have said whatever.
Got it, got it. The only other thing, Judge, and I know I hate to go back to this thing, but I have it listed on here. Your Honor, will Your Honor make a rule? Your Honor needs to be heard, or I don't know if Your Honor heard Mr. Davila, a response on that. I need a ruling on the documents before March the 4th.
I can't get there. I'm trying. I'm really trying. I have a list of things that I would like to put on the record. We're not.
No, Judge, the list of the 4 documents.
I'm going to do that at the end of this hearing,
got
but
it.
you all keep chiming in and saying more things, and
Understood.
I have a ruling. I can't get there if y'all keep arguing. But I do want to give all persons all the time necessary to be heard, because this is an important matter and there's many moving pieces. Anything else from any person?
No, Your Honor.
All right, there are 4. There are 7 agreements that were stated to the court on the record. The first is depositions to be taking place on March the 4th. 2, the exchange of bank documents. Number 3, there's some other documents that were stated on the record. Number 4 was a reset of the hearing until March the 19th, and the court has been explicit about that. March 19th is set for a docket control conference subject to the parties filing fiats before February the 13th at 5. And the court will resend and set those matters. File any objections if necessary, I guess. There's a reset of that motion for summary judgment. That was 5, subject to it being reset. 6 is that docket control conference on March the 19th at
9 a.m.
Thank you. Number 7. As to those documents, look, I'm going to tell you what's on the record. I did have an opportunity to receive, review, and consider those 4. It isn't crystal clear to the court as to 1, 2, and 3. I guess 4 is a little more clear. The court hereby approves of 4, number 4. The other 3, the court heard. You can ask questions at the deposition and see what happens there, and then come back on the 19th and say they weren't needed or they were, or whatever, and crystallize whatever arguments are necessary. So 1, 2, and 3 are denied. 4 is granted. Anything else on this case, Mr. Rodriguez?
Hold on, Judge. I'm denied the opportunity to ask billing statements from Ernesto Cavazos.
I have ruled.
Honor,
Anything
court is-
else on this matter?
The court has made a ruling,
Well,
Your Honor.
hold on, Judge.
Anything? Any new
Well,
information?
I'm gonna need it, Your Honor. In that case, I'm gonna be issuing another notice of deposition. I'm gonna want the court to make a written ruling because I'm gonna have to perhaps consider.
So this is all in the future. The
you're-
court welcomes you to do anything to
Well, what I'm
protect and to
asking- what I'm-
safeguard your client's rights. Absolutely.
The-
Anything else that's
Yes.
pending for today?
I'm asking the court to make a written ruling on the denial of the 4 of the subpoena exhibit, specifically Exhibit 7. The subpoena that was set for today, I'm asking the court to make a written ruling and reduce Your Honor's ruling to writing as promptly as practicable. So I can see what we need to do to preserve those rights of
Sure.
my client.
Absolutely. All right. Anything else?
I would suggest then that he file a request for findings of facts and conclusions of law. Your Honor.
All right, folks,
I know
we're
what I need to do,
we're
Judge.
venturing into new territory. Look, folks,
I do
I
need
wish
to
all
realize-
persons well. Everyone is